1257, my lord.
Sir, 1284 was notified. It was modified to 1257.
Yes.
Then it should be proportionately decreased. On the other hand, it has been increased. How we jump into the new notification? As on the date of advertisement, whatever the existing, that is required to be applied.
For that reason, your lordship, 13-10-2017 says that it has to be interchanged among the disabled persons.
That is contrary to subsection 2 of section 34. Yes.
Your lordship, the notification is annexed as Annexure 2, page number 37 in the main writ petition.
Page number?
Page number 37, your lordship.
37.
Your lordship.
There is no page number 37 here.
Of the writ petition, main writ petition.
No, from this.
In this, your lordship. That is, your lordship, point number 9.
Page 12.
Page 11, your lordship. It
11.
starts from page 11, point number 9. Where a vacancy under section 34
From some other portion.
page number 11, paragraph number 9, Roman 9. Where a vacancy under section 34 of Rights of Persons with Disabilities Act 2016, not caste-based, the reserved, non-reserved category of which the disabled candidate selected for nomination will be counted against the same reserved, non-reserved category. The provision of Rights of Persons with Disability Act issued by the Government of India will be followed in relation to who will be called disabled for enrollment in educational institution and what will be the system of reservation for different types of disabled. The basic objective of the Rights of Persons with Disabilities Act 2016 is non-discrimination in government employment, according to which disability will not be a hindrance.
It seems you have wrongly translated this portion. Come to page 13, next page.
This paragraph number is 11, your lordship.
Paragraph number
11.
Yes.
That is continuing, your lordship.
No, continuing, but it is wrongly continuing there. You should read page 13. After reading page 11, you come to page 13. Cannot be filled in any recruitment year.
Your lordship, it is apparently it is the printing mistake, your lordship. It is not the typographical error, it is the printing mistake. After page number 11, it is number 13, your lordship. Apologies, your lordship. Where a vacancy under section 34 of the Rights of Persons with Disabilities Act 2016 cannot be filled in any recruitment year due to non-availability of the above mentioned disabled person or for any other sufficient reason, it shall be interchanged between the four categories in the same treatment, and only if no person with disability is available for the post in that year, the employer shall fill the vacancy by appointing a person other than the person with disability. Such vacancy shall not be carried forward to the next year.
Shall not be carried forward?
It has to be filled, your lordship.
No, this is contrary to Act 2016. It says that there are two issues. One is carry forward. Even in the next recruitment, if candidates are not available, then only you can interchange.
Your lordship.
That is the position here.
Your lordship.
Case.
Your lordship, the Act says, I will clarify, the Act says that when the seats cannot be filled with that specific category of disabled person, then that particular seat will be carried forward.
Yes.
And thereafter in the next year, they'll again try, the government will again try to fill it with that same category person. If then also they do not get any candidate, then it will be interchanged, and even after that, if it remains unfilled.
No, we have not yet reached that stage.
Your lordship, Your Lordship, this is the state notification which was being followed in all the.
Therefore, you don't have case.
Therefore, I have the case for the reason of this notification as well as the earlier selections when I gave
No,
my merits.
between 2016 to 2017, was there any recruitment?
Your Lordship, there were recruitments, Your Lordship.
So, which is
From
the-
2017, Your Lordship, in accordance with this notification, there have been recruitments, Your Lordship.
Huh?
In accordance with this notification, there have been recruitments, Your Lordship. I'm affected
This matter is relating to which post?
to the post of engineer, Your Lordship.
Assistant engineer.
Engineer.
Between 2017 to 2016 to, in the year 2016 the date on which the act was issued, till 8/11/2017, was there any recruitment? So as to say that earlier it was notified, it was not filled up for death of candidates, and then the vacancies have been carried forward to 2017 recruitment. Again in the 2017 it is not there, therefore interchange.
So, under.
For the first time, carry forward is required.
Your Lordship.
Huh.
So, I believe.
So you don't have case.
Your Lordship, I have the case for the reason that there were 3 advertisements issued by the same notification, Your Lordship. This particular notification, Annexure 1 of the writ petition, 3 notifications were issued. I am affected by advertisement number 2, Your Lordship. Whereas the other advertisement.
Prior to advertise 2 of 2017, was there any advertisement in respect of assistant engineer civil?
That the state.
Without that, you are not entitled. You will have your argument could be accepted, provided if before 9/11/2017 there was an advertisement for dearth of candidates, vacancies have been carried forward to next recruitment.
Your Lordship.
That is not the position here.
Your Lordship.
After 2011, my instruction is after 2011, this was there.
First time recruitment.
So, Your Lordship, the earlier notification, 2007 notification, as per my knowledge, that notification must have been applied, which has been annexed in the counter, Your Lordship. My case is only based on the issue, Your Lordship, that this notification was being relied upon from the starting of the advertisement for all the procedure for filling up the post.
Whatever it may be, please take this. You have 2016 Act?
Your Lordship.
Read subsection 2 of section 34.
Your Lordship. When in any recruitment year,
Not when, where in any recruitment.
wherein any recruitment year, any vacancy.
Read
not-
slowly so that you will understand.
Where in any recruitment year, any vacancy cannot be filled up due to non-availability of suitable person with benchmark disability or for any other sufficient reasons, such vacancy shall be carried forward in the succeeding recruitment year.
Now
And
stop at that. And now apprise. Where is the carry forward?
in my case, Your Lordship, they carried forward by the new notification which was published.
Not new notification, only this. That is the reason I am saying, we are saying that this act has came into force in the year 2016. Between 2016 to 8/11/2017, was there any recruitment to the post of assistant engineer or not?
No, Your Lordship, because these posts.
Then you don't have case.
Your Lordship will.
Anything else?
Yes, Your Lordship.
Yeah.
Your Lordship will consider this, that this notification was the extant notification that was being followed for all the purposes, right from the beginning of the procedure of the advertisement. And even during the preliminary examination, this particular provision was applied, and therefore no categorization, no subcategorization was done, even from the preliminary examination.
From the advertisement, you point out where is the classification of subcategorization?
There is no classification, Your Lordship.
In 9/11/2017, there is no.
No classification, Your Lordship.
Show the advertisement copy.
Your Lordship, I have only one translated copy, whereas while in the main writ petition, the advertisement is at page number
Advertisement does not
98.
describe how do they classify? This
40% or more disabled.
now, so for a classification in under section 33, 34, blindness, load 3. Out of 52 vacancies, how you subcategorize blindness and low vision, deaf, hard hearing
That is there, my lord, in the annexure 4, my
in
lord.
the advertisement?
The annexure 4
Advertisement.
for the mains exam.
Huh?
Advertisement for the
advertisement.
written examination, my lord. Annexure 4 at page 59 of the writ petition.
Reclassify for ortho. They should have. What is it? What is the date? 24/1/2021. Yes, ma'am.
So there was no subcategorization in
The
the.
subcategorization was undertaken on 24/1/2021.
No. Date
This is the
6
main
February.
examination.
The
Yes. Digital result.
main examination was conducted on 6/2/2019.
No, advertisement.
The notification was that of 6/2/2019
This advertisement
for the mains examination.
for mains examination and it was issued on 6th of February.
It was done undertaken on 6/2/2019.
Your Lordship, even in that notification, Your Lordship will note that a total of 41 seats have been given to person with disability, and that is also not
41?
total.
Total is 50.
51 seats have been. If we calculate all the number of seats, it is 51. It comes to 51, Your Lordship.
Then how subcategorization?
Subcategorized. Yes, Your Lordship.
How 51 vacancies have been distributed among 3 categories? 3 or 5 categories?
Four cat.
41.
5, 8, 11. It's multiple disability. Total.
This annexure 4 shows the vacancy under disability and disabled persons. 41 vacancies only.
My lord, later on, my lord, what has happened, my lord, total was initially 963 was advertised. It was increased by the department concerns, my lord. There are,
Where is the corrigendum to this?
yes, my lord, that corrigendum, last corrigendum is at annexure 5, just at page 68, my lord.
5, 8.
It was reduced.
Yes, my lord, total.
But if it is reduced, unfortunately it has to reduce on physically handicapped.
1257, my lord. Post-
Sir, 1284 was notified. It was modified to 1257.
Yes.
Then it should be proportionately decreased. On the other hand, it has been increased. How?
My lord, that is, my lord.
4% of 1284 would be 51.
That
Huh?
depends on the roster, how many left over. That's it.
Ultimately, you have taken 51 vacancy or 50 vacancy?
41 vacancy if we calculate the entire number in the mains. And 4% of 1284 would be 51 seats.
If it is 1257?
If it is 12,
1257, my lord.
Correct. If it is 1257, 4% is?
4% is around 50 point something.
50.
50.5. 50.5 perhaps.
Anyway, round figure to 50.
Your Lordship.
Yes.
So even during the preliminary examination, because they had, the state had not done any categorization, so the students who were shortlisted for the mains examination, it was not in accordance with the categorization. It was only in accordance with the notification of 2017. Even
Have you challenged the main examination?
Your Lordship, because I was not affected by the mains examination, I am trying to explain as to
No, after unsuccessful, can you say that in the main examination there is a in the main advertisement?
No, Your Lordship, for that reason, I would point out that I am not aware as to what they have applied for the results of the mains examination. Reason being, Your Lordship, the new notification has been notified in the Gazette, Your Lordship, on 25/1/2021.
We are not concerned with that. As on the date of advertisement on 9/11/2017, the resolution is 13/10/2017,
Your Lordship.
read with Act 2016.
Your Lordship, for that reason, I will point out. So let's go here, results. Your Lordship, this notification came in the Gazette on 25th. It was notified on the 25th, whereas
25th of October.
25th of January 2021. Whereas the result.
13/10/2017.
No, Your Lordship, the new notification.
No, why are you jumping to the new notification? As on the date of advertisement, whatever the existing, that is required to be applied.
For that reason, Your Lordship, 13/10/2017 says that it has to be interchanged among the disabled persons.
That is contrary to subsection 2 of section 34.
That is the act, Your Lordship.
Act will prevail over resolution or what?
Your Lordship, but this was what.
Act will prevail over resolution.
Your Lordship, this was being applied in all the advertisements.
Correct. If they have committed illegality, you want us to bless the illegal order in perpetuating the order.
No, Your Lordship, I'm only.
Subsection 2 is against you or not?
It is against you, Your Lordship.
Then how can you?
On the principle of, Your Lordship, I'm only on the principle that once the game has started, the rules cannot be changed, Your Lordship. So earlier they had been applying the notification 13/10/2017, and in that notification, because it was the seats were to be interchanged among the persons with disability, Your Lordship,
No,
that was being done.
Clause-
For that reason, the
clause-
entire process.
Clause 9 of resolution dated 13/10/2017 is contrary to subsection 2 of section 34 of 2016 Act. So 2016 Act will prevail, not the resolution. No, 21 it is a prospective list. That is what our argument is that.
That's why, my lord.
Correct, sir. This is prospective. That is what her contention.
Your Lordship, even in the new
And
notification.
that's why we not see in the earlier High Court, in Atul Ranjan case, we not quashed clause 9 of that notification, that being
Madam, you don't have case, anything else?
Yes, Your Lordship, one more thing, Your Lordship. Before this new notification came of that of 2021, the earlier notification was being applied, Your Lordship, for all the purposes, Your Lordship, in all the examination, Your Lordship, even after the Atul Ranjan case, Your Lordship. Your Lordship will have a look at the case of Atul Ranjan.
Thank you.
Act will prevail. Provide for interchange in the first recruitment.
Carried forward.
Yes, ma'am.
Your Lordship, in Atul Ranjan case, Your Lordship, I will read a paragraph which has been submitted by the state and which has been noted in the order, Your Lordship.
They are bound by statute, madam. Act 2016.
I'm just trying to explain, Your Lordship, as to how this particular notification, the earlier notification had been applied even after the Atul Ranjan's case, before the new notification could come, Your Lordship.
But 2016, subsection 2 of section 34 of 2016 Act has been taken note of by this court.
Your Lordship,
Subsection 2 of section 34 of 2000. So please point out which is the relevant paragraph. That we are required to ignore that subsection 2 of section 34.
Your Lordship, paragraph 16 at page number 16, continuing, in the judgment itself, it has been submitted. Coming back to the case of the petitioner, learned senior counsel appearing on behalf of the commission has argued that the petitioner cannot successfully establish infringement of his legal right in respect of 63rd combined competitive examination, as he did not submit his application with form 6 under the rules certifying his multiple disability. He has contended that in any view of the matter, after having participated in the process of selection, he cannot subsequently turn around to question the process of selection itself. He has further submitted that in any view of the matter, since for the first time the petitioner has obtained a certificate of his sufferance from multiple disability in accordance with the statutory rules on 9/4/2019, he cannot question absence of provision for reservation for the said category under the advertisement for 63rd and 64th combined competitive examination, since he did not hold the requisite certificate in support of his claim. He has further submitted that now, since the selection process based on the advertisement for 63rd combined competitive examination is over and 64th combined competitive examination is underway, and there has been substantial progress already, the petitioner cannot be granted any relief even if the court has notified any illegality in the advertisement, in the said advertisement. So it has been submitted by the state that the process was already underway, and now the provisions cannot be, the petitioner cannot be accommodated or given any relief. For that reason, I am pointing out, Your Lordship, that this judgment dates, the date of the judgment is, Your Lordship, 12/12/2019. And this notification, which is being applied, that came
12/8.
12/12/2019. 12/12/2019. The judgment, Atul Ranjan judgment. And this notification that is being applied on me, that was notified in the Gazette on 25th, while the result for the mains was published on 24th itself, Your Lordship. And in the mains result, it has been said that this notification is being applied on you.
Sir, yes, take down.
Your Lordship will,
We heard you sufficiently.
Your Lordship will grant me one more date, Your Lordship.
No.
Your Lordship, just one more date.
Sorry, madam.
The query that Your Lordship has put forward, I will try to satisfy Your Lordship on.
Sorry,
that
madam.
point.
We have heard you sufficiently. Take down.
Your Lordship, only one short date, very short date. Your
Oh, why?
Lordship. Your Lordship, I try to satisfy Your Lordship on that particular query that.
What particular query? Are you going to improve the section, subsection 2 of section 34 of the 2016 Act?
I'm stating before Your Lordship that the entire process was undertaken as per that earlier notification, and because that entire process was undertaken under that earlier notification, that can also be one reason why I was unable to qualify, Your Lordship, because in the beginning there was no subcategorization being followed, and all the persons with disability were.
But you are not challenged. You are not challenged the advertisement. Initial advertisement should have been challenged, stating that subcategorization is not forthcoming.
Your Lordship, I have challenged.
No, after unsuccessful, you have approached this court. Have you challenged the 9/11/2017 advertisement?
I was unaware on
How can you be unaware when the advertisement is there?
Because the advertisement, Your Lordship, because the advertisement, the mains examination, that.
Advertisement dated 9/11/2017 does not reveal the subcategorization or not?
No, Your Lordship.
No. Then why you did not challenge?
Because there was no no need for me to check,
Why?
Your Lordship, because earlier, as per the earlier notification, there was no sub-categorization being followed, Your Lordship, because it was interchangeable.
No.
For that reason, the state did not,
No, in terms of subsection, section 34, is it not necessary for them to categorize?
in terms of the notification, Your Lordship.
Not notification, why are you going, act will prevail or notification will prevail?
Act will prevail.
Then how many times you want us to repeat the same thing?
Your Lordship, we'll give you one more opportunity, Your Lordship, a very short adjournment, Your Lordship.